Well, I appreciate you joining me. We're going to dive right into the Supreme Court. They recently declined to hear a case surrounding parental rights. It's a pretty big deal and a very interesting case that they won't be hearing. What can you tell us about this case?
Yeah, this is a case coming out of Wisconsin against the Eau Claire County School District in Wisconsin and the Seventh Circuit. And the Supreme Court decided that they were not going to take up what was a challenge to the constitutionality of a school policy keeping gender identity information of minor children, keeping that information confidential from their parents. Now, this is a shocking policy, but it is one of about 1,200 policies across the country. In fact, about 12 million American school students and public schools across the country are subject to policies in which they are attending schools where, if they identified as transgender or gender dysphoric or were using different names or pronouns, their parents could not find out that information on the child's say so. All the child would have to do is say, keep that information confidential from my parents. And that's exactly what would happen. Now, again, 12 million school students and about 1,200 school districts across the country have these particular challenges. But an interesting thing to note about this particular case coming out of Wisconsin is that the individual group of parents, a coalition of parents, did not have any children who identified as being transgender or with gender dysphoria. Now, why is that significant? Well, it's significant because the parents challenged the policy on a facial basis. This was not what's called an as applied constitutional challenge. Rather, it is facially unconstitutional. I think that's precisely the correct approach. I think they have standing or the ability to suffer a concrete injury sufficient so that a court can rectify that injury. But this is, interestingly, the second dismissal of a case like this with a request for review from the Supreme Court in just this term alone.
It's remarkable. And the fact that this is the second time this has happened, I have so many follow-up questions here, but one of them, being somebody, I am not a lawyer, I'm not an attorney, I'm not a legal mind, right? That's not what I do. But you look at this and you say, okay, well, the parents don't have standing in the eyes of the court system so far because nothing bad has happened to them yet, essentially, right? They haven't been
Right.
harmed because they haven't had a child who's gone through this. That seems so bizarre to me that you have to have gone through something or have had a kid who this has happened to, and your rights have to very literally be threatened. The threat of your rights being threatened isn't good enough. How common is that in the law? Because I think some people have heard that and they've been a little shocked by it.
Yeah, I think it's increasingly common in hotly charged political issues. And in fact, in his dissent from the denial of review, Justice Samuel Alito, he was joined by Justices Clarence Thomas and Brett Kavanaugh, he said as much. And he said, we're seeing an increase in challenges to standing, specifically so within the context of parents challenging these unconstitutional policies. And he alleged that courts are declining to take up cases specifically because they want to avoid hot button political issues, as opposed to taking the constitutional challenge head on. And listen, the Supreme Court has actually said in the past, simply being subject to an unconstitutional policy, having children subject to an unconstitutional policy is itself sufficient to confer standing. You don't have to be injured before you actually can demonstrate that there's an imminent possibility of harm. The harm's already occurred because the parental right has been breached by the school district in Eau Claire, Wisconsin.
Let's talk also about the fact that in most school districts, in many, if not most, in order for a nurse to give out Tylenol, Pepto-Bismol, any over-the-counter or prescription medication, the parents have to sign a form allowing that to happen, do they not?
They absolutely do. Listen, you're a dad. I'm a mom. I have 3 of my own. My daughter had to get a waiver signed when I went with her to get her ears pierced when she was a teenager. My son's school nurse calls me to administer so much as Tylenol for a headache. We do not let these minor children sign contracts, register for the draft, buy alcohol, buy cigarettes, a multitude of restrictions. And yet suddenly within the context of gender identity, all the courts have taken a hands-off approach and have presumed that a child is aware of the lifelong consequences of a desire to ostensibly transition. What is particularly pernicious about these school confidentiality policies is that they result in what's known as social transitioning. Here, Johnny, we'll let you live as Jane. We'll let you use the girls' bathroom. We'll let you play on the girls' hockey team. We will let you use preferred pronouns, and the teachers will abide by that. That facilitation, invariably, the research tells us, leads to an ultimate medical transition. The use of puberty blockers, then cross-sex hormones, and ultimately surgical intervention. And these are consequences that a minor child at the age of 14, 15, 16 cannot possibly conceive of. They will have no understanding of whether or not they want to father a child, bear a child, carry a child, nurse a child, whether or not they ultimately want to be fertile in the future. These are not consequences to which these minor children have full awareness. We know the prefrontal cortex doesn't fully develop until the age of 25. Minor kids are restricted specifically because at that age, their parents know best.
When you're looking at this, you cannot have a situation, and you would know this better than anyone, where you have 1,200, even 100 school districts around the country. But again, 1,200 is a massive number with policies like this, where parents are fighting back, upset, frustrated, and not have the federal government in some way weigh in on this, have the Supreme Court in some way weigh in. What will it take, in your view, to get the Supreme Court to a place where they are willing to take up one of these cases?
Yeah, that's a great question. I'm just going to sort of paraphrase Justice Alito in his dissent from the denial of the petition for cert, in his saying that this was a question of, quote, increasing national importance, and actually cited the numbers. The 1,100 then, at the time of the authoring here, school districts who had ostensibly put these positions, these formal policies in place, saying that they were doing it in order to protect the confidentiality of minor children. They believed it was a violation of federal privacy law. I've actually written an extensive legal memo on the fact that it is not a violation of privacy law. And in fact, it's the parental right that is carried through privacy protections until that minor child reaches the age of 18. But I think it's going to take a different type of vehicle. I know of a case coming out of the 11th Circuit Court of Appeals out of the state of Florida, where this parent didn't just bring a facial challenge to the constitutionality of a Leon County School District policy, the exact same confidentiality policy, but also it was an as-applied challenge in that her daughter was meeting privately with school counselors, school administrators, being referred to by a different name with different pronouns. She was on the track. The train had already left the station, and by the grace of God, she discovered these private meetings, confronted the school leadership, talked to her daughter. Her daughter was able to, under her mother's care and nurturing love, be able to say, I'm actually really worried about something else. I'm concerned or depressed or anxious about something else. And in fact, she not only has the ability to bring this facial challenge, saying it's unconstitutional as applied to everyone, she is bringing also an as applied challenge, saying, this is what happened in my life. I've suffered a concrete injury. That is the particular case. It is on its way, I believe, up to the Supreme Court. We may actually see a petition for review filed as early as this term. And that is the type of vehicle I think the Supreme Court is ultimately going to have to take. At one point or another, there will be parents who have suffered that irreparable damage of having their child socially transitioned. And at that point, I believe the Supreme Court cannot look away.
You think, and I know the case that you're talking about, it's a really, really interesting one, but you look at this and you think, okay, these school districts, they're not only, there's a couple of things they're doing. They're concealing other issues that a child might be dealing with, right? So you're confronting this one potential symptom that you're assuming is the main issue, when there could be other mental health issues going on that are actually not being treated, which I think is a bigger, broader issue with this issue, of gender in itself. But beyond that, I mean, you look at this and you say, you're driving a real wedge, are you not, in between parents and children? Let's just talk from a social, familial perspective. Here you have the school saying, hey, you don't have to tell your parents, we'll take care of it. This is the very thing that has been talked about for decades when it comes to abortion, when it comes to
Yeah.
birth control, these other issues. Now it's happening with gender. I don't know if you want to reflect on that, but that seems to be a pretty big deal.
It absolutely does. And we're seeing no greater encroachment on that 14th Amendment parental right that the Supreme Court laid out in a case in 1923 called Meyer versus Nebraska. We have not seen this level of encroachment on the parental right itself since the origin, essentially, of substantive due process doctrine for parental rights embodied in that Meyer case. But we know parental rights actually are pre-political. They are natural rights. They derive from the biological relationship between parent and child. This is under God's authority. We have been granted the exclusive solemn responsibility to raise these children up the way we see fit. And this is something within the concept of gender identity. We are seeing sort of a clash play out in real time as far as parents who are seeking, quote, gender affirming care for their minors, or parents who are seeking information about their apparently transgender children or how their child identifies at school. Nothing could go more fundamentally to the nature of the development of who we are as human beings than how we identify. Are we male or female? We know that immediately at birth. It is not identified. It is immutable. The Supreme Court's actually said sex and race, two immutable characteristics. They are derived by, the Supreme Court has written, accident of birth. They are unchanging. So all of this common modern parlance coming through a lot of the education systems. And I'm a fan of public education if it's ideologically neutral. I worked as senior counsel at the Department of Education under Trump in 2019. This is possible, but we have to get teachers' unions and ideologues, especially so within the concept of gender identitarianism, out of the American classroom. We are not doing a good job of that, and we have gone now beyond the realm of just instructing. We are indoctrinating, and the parents themselves are finding their familial relationships directly implicated.
And I think we're going to see more teachers and families speak up, because the majority of teachers and families are not comfortable with this, obviously, and do not want to be a part of it in many cases, as we've seen many of these teachers speak out. Sarah, I appreciate your time. We'll definitely have you back soon to break down more of this important issue.
Thanks so much for having me.